Welcome back to the Federal Drive with Terry Gerton on Federal News Network. The protection of whistleblowers is a key tenet in our concept of government transparency and accountability. But that bargain seems pretty tenuous today. For more on the current environment and what might happen with a whistleblower complaint, Stephen Cohn joins me now. Mr. Cohn, thanks for joining me today.
Thanks for having me, Terry.
We just passed the 100-day mark of the second Trump administration, and with all of the disruption, everything from EOs to Doge, I'm curious, from your perspective, what's the current environment for whistleblowers?
Well, it's been the worst environment for whistleblowers. I've been practicing law for 40 years, representing whistleblowers. And this is the worst. We have seen progress over time. For example, for federal employees, the Civil Service Reform Act was passed in 78, it was fixed in 89, amended in 94, amended again in 2012. And we saw progress. Then all of a sudden, we saw the special counsel being fired, even though he wasn't supposed to be. He's supposed to be a for-cause-only termination. And now we're witnessing the Merit Systems Protection Board to be without a quorum once again, which means they can't give relief to employee whistleblowers. So this is just, nothing like this has ever happened before. And you see it in other areas. You see it with changes in policies and procedures and people leaving offices who are trained investigators, the inspector generals being terminated. So in the first 100 days, we saw essentially an attack on whistleblower law rights that was unparalleled, and I think shocking and took a lot of people by surprise. So that's where we are as of a week ago.
Isn't it sort of a paradigm that whistleblowers and the protection afforded them is essential to the transparency of government, right? That's the basic concept that we're dealing with.
Yeah, absolutely. So this was recognized 50 years ago, and it's been proven empirically that whistleblowers are the number one source of all detection of fraud, misconduct, violations of federal policies, contracting. When I say proven empirically, through statistical analysis and through both academic but also studies done by law enforcement over the years. So you have the number one source of all fraud detection being essentially crippled by these attacks on fundamental whistleblower rights. But I want to now give an analogy, because this is what I see happening. We live in a country of the rule of law. The laws are still in place, and it's not just the Whistleblower Protection Act. It's the Privacy Act. It's the Inspector General Act. And it's other laws, First Amendment, that are designed to protect the right of employees and federal employees to raise disclosures. These laws have not been amended. I doubt they will be. So you saw this really lightning speed attack, but now I kind of can compare it, and the analogy won't be very good, to like in World War II when Germany attacked Russia. And they marched all the way through. It was blitzkrieg, took everyone by surprise. No one was aware. But all of a sudden they got right up to Moscow and everything stopped and everything reverted. And that's, I think, the message I have here today. The rule of law remains. We represented a whistleblower, Tony Savage. And in the first Trump administration, they also lost their quorum. And she had to wait years for her case to be adjudicated, over 10 years. But at the end, she got a very, very large settlement. In other words, she could survive it. The rule of law came in. She was wrongfully discharged as a whistleblower. And what's the end result? The U.S. government, the taxpayers, had to pay a massive amount of damages. So today there may be no quorum, but that doesn't mean your rights don't exist. It just means you have to be a little more patient, develop new tactics, push forward. We can also hope that the Trump administration starts mitigating some of their actions. Doge went why did they just start firing people? Why did they just start knocking out these commissions, including now like the EEO and others? At some point, they may realize that this was counterproductive. And the courts may also step in. The courts can still step in and reestablish the MSPB with a quorum. So we're just going to have to sit and wait. But even if the courts don't come in today, the rights remain. So people should assert their rights, file their cases as permitted under law. Don't sit back and say, well, there's nothing I can do. The special counsel's gone. The MSPB doesn't have a quorum, so I should just do nothing. No, don't let the statute of limitations run. Meet the qualifications, file, which is your right, and then we'll see how this plays out.
I'm speaking with Stephen Cohn, one of the nation's leading whistleblower attorneys. So let's talk a little bit more about what it takes to put a whistleblower case together. If someone thinks they've seen, something that needs to be reported and their internal agency is not taking action, they think a whistleblower report is their appropriate action, how much information do they really need to get together, and what's the process for that?
Gathering evidence is essential. Documents, emails. Building your case while you're still an employee. Once you realize any mild retaliation, any mild pushback, when someone just says, hey, stick to your lane, don't get involved. So you haven't been fired yet, you haven't lost any benefits, but you've got the red flag up. That's when you have to start building your case. That doesn't mean you file or you shove it under somebody's nose, but you start collecting the emails, the evidence, and building it. In point of fact, we've done the analysis. 92% of all retaliation cases that result in a termination are based only on an employee's raising concerns with supervisors or internally. So that's when you're going to get hit. So don't think, oh, I'm not a real whistleblower until I go to the Inspector General, or I'm not a real whistleblower until I go to Congress. Do not wait for that. Because most cases, that friction and retaliation is supervisor or second line supervisor based. Collect your evidence immediately and just start building your case. You have to understand that the employee has an initial burden. It's very low, but they have to show what's known as a contributing factor. They have to show that your disclosures contributed in some way to the adverse action. And as long as you're still employed and you're able to put facts together, you should be able to satisfy that burden. So prepare your case on the spot. Also, I recommend, remember, your job is a tremendously valuable asset. It can be worth $1 million or $2 million in long-term stream of income. Don't risk that. If you're going to start raising concerns, get legal advice as quickly as possible, because you have to treat your job like you would like the sale of your house. It's a valuable asset. Just don't think you can do it on your own.
Well, the National Whistleblower Center can be a source of that assistance, correct?
Absolutely. So the National Whistleblower Center, which is at whistleblowers.org, has an attorney referral program where lawyers who are willing to represent federal employees and other whistleblowers are on our lists. So if you send in the intake, which is strictly confidential, covered under attorney-client privilege, it's reviewed and sent out to these attorneys. And there are a good number of attorneys who want to take on federal employee cases, even in the current environment.
So people who are thinking about this can get advice and assistance really before they even embark, because this can be a pretty dangerous even approach to solving a government issue.
Let's put it this way, and this is the paradox. The more your information is valid and the bigger the issue you're presenting, the higher your risk of retaliation. Because think of it, the supervisor who may have committed misconduct, are they going to admit to that? Are they going to walk over to the U.S. Attorney's Office and say, put on my handcuffs, I was falsifying time records? Of course not. They're going to target the source. That's why the internal whistleblowing tends to be the most dangerous form, because the supervisors and the managers who may have committed misconduct have a motive to discredit the whistleblower. So that's why you have to be very cautious at the very beginning. Hey, everything may work out. The system may work. Great. but be prepared if it doesn't.
That's really important advice. I've been speaking with Stephen Cohn, one of the nation's leading whistleblower attorneys and the author of the new Whistleblower's Handbook, a step-by-step guide to doing what's right and protecting yourself. Thank you so much for joining me.
Thank you so much, Terry, and good luck with your programs.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Listen to the Federal Drive on your schedule. Subscribe wherever you get your podcasts.